Good evening. Welcome to the PhD to Startup Workshop series. Today we'll be discussing a very important topic, intellectual property. I was going to let you guys know that the Willie Nelson concert is at the Greek Theater, not here, so just making sure that you are in the right place. We are BPEP, the Berkeley Postdoctoral Entrepreneur Program. We aim to educate postdocs such as yourself and provide you with an entrepreneurial toolkit. We additionally would like to collaborate with local businesses, such as Kilpatrick Townsend, hopefully, and to foster a mentoring within yourselves. We also assist in the building of startups, so we attempt to provide grassroots support and education to help you get your startup off the ground. These events, they fall on the last Thursday of each month typically. This time it's a week forward due to schedule conflicting. So the last Thursday in the foreseeable future for the rest of the year, that we will be one of these events. So I will be brief. I'd like to thank the sponsors, in this case, the Visiting Scholar and Postdoctoral Affairs Office and Kilpatrick Townsend, which we have two speakers from today. Without further ado, I will introduce our first speaker, Mike Cohen. As the Office of Technology Licensing's Director of Innovation Ecosystem Development, Mike drives initiatives and agreements that catalyze the commercialization of UC Berkeley innovations and support the funding of campus research. In this role, Mike collaborates with faculty, students, startups, established companies, entrepreneurs, investors, and intellectual property attorneys. Mike has worked with over 100 startups, and he has spearheaded the licensing of innovations in numerous areas, including biofuels, medical devices, photovoltaics, semiconductors, software, smart grid, wireless sensors, nanotechnology, and biomimetic inventions. So please give Mike Cohen a warm welcome.
Thanks, Lance. Here are the goals for this 20-minute session. Let's see, there's no clock here, so I'll just flip this right. Oh yeah, great. First, I want to help you guide your transition from student to entrepreneur. Second, I want to give you some ways to leverage the vast UC Berkeley innovation ecosystem. And third, I'd like to familiarize you with licensing, patenting, and disclosing intellectual property in the campus. Now, for these latter two, patenting, I'll leave it to my colleagues to focus more on that. So with that in mind, here's the agenda. I'll spend a few minutes just talking about ways for you to think about spinning out startups and ways for you to think about licensing intellectual property rights. And then maybe we'll spend a little time here if I have time. And then feel free to ask me questions during and after, and I guess we'll have a panel discussion as well. So about 10 years ago, we started to ask questions about how innovations get commercialized, both at UC Berkeley and also at the National Lab. A lot of people think it's a linear process. It's just research leads to an invention, which leads to a patent and a license, and then a startup or a company. But we looked at about 60 innovations, again, from the National Lab and the campus, and looked at the stories, and started to figure out what catalyzes these things and how do they happen. And it turned out there's four common pathways for commercializing technology at research universities and national labs. I call them the 4 M's: morphed, mined, milked, and marketed. To explain this to you and show you how it can work maybe in your context, let me just give you an example of each. The first pathway, the morphed pathway, occurs when someone in a research lab group or a team of people just naturally or organically move from, say, doing applied research to a alpha or a beta product, and before you know it, they're working on a product and spinning out a company. So it just comes right naturally out of the lab team. This is the most common pathway for commercialization technology at UC Berkeley, and here's a bunch of examples right here. And let me just give you one, for example. Let's take Cali Solar. Several years ago, a research team figured out how to make solar photovoltaics out of dirty silicon, which helped lower the cost, and so the professor and some of the grad students spun out a company, and they eventually were quite successful, and they eventually actually located the company in Germany, but it's one example of a morphed technology. The mind technology commercialization is the pathway that's growing the fastest at UC Berkeley, in part because the business school is becoming much more of a font of entrepreneurs. And this occurs when entrepreneurs on campus, which in many cases are MBA students, scour the campus for innovations that they want to use in classes, in business plan competitions, or just to start companies. And when they strike something that interests them, then they might write a business plan, form a team, and try to spin out that company. Here's some examples here. One of them is, let's do Adoratech. Some students came to me several years ago and asked if I could introduce them to some green technology that was interesting. By the way, this presentation is available on the web, so you don't have to take notes or take pictures if you don't want. So these students came and were looking for some green tech. I introduced them to some professors that were working on smart lighting. So they created a company, Adoratech. They came in second in a business plan competition. They launched in one of the incubators on campus, and they got some funding. They moved to San Francisco, and then they were eventually acquired by one of the largest lighting companies in the world. That's the mind pathway. The milk pathway of commercialization is growing at UC Berkeley because as state funding goes down, corporate funding is going up, and a lot of this corporate funding results in collaborations of which the innovations then get commercialized by the R&D organizations of those collaborating companies. Here's some examples here. One of them is Google. They funded research on 3D photo imaging, and a lot of that became what is now Street View on their Google search tool. And then finally, the marketed pathway of commercialization occurs because the fact of the matter is most of the innovations developed at a research university like UC Berkeley aren't really ready for commercialization. Either the technology is not proven or the markets are too nascent. So a lot of times what we'll do is if we think it's promising, we'll still go and patent the technology, and then we'll regularly market it to entrepreneurs, startup companies, established companies, and investors. And often, eventually, the timing becomes right, and that technology gets commercialized. An example here, let's pick luminous devices. Several years ago, EE professors figured out how to make LED lighting much less expensive, and that space is all about the economics. The technology they developed is called a laser liftoff. And so years later, this company called Luminous Devices, which was actually a spin-out from MIT, licensed the technology, and now they're one of our largest revenue-producing licenses on the campus, hundreds of thousands of dollars per year from those little LEDs that go into our lighting now. So those are the four pathways: morphed, mined, milked, and marketed. Let me just say a little bit more about startups. These are the common pathways for startups, morphed and mined, and we've seen that there's basically two types of startups. One's a spin-out, one's a blast-out. The spin-outs are often grad students and postdocs. They take advantage of all of our ecosystem resources, like our incubators and accelerators and mentor networks. The blast-outs are often very high-profile professors. When they spin out a company, they get their funding right away. They get their management teams. They find offices, so they don't need our business plan competitions and things like that. 80% of our spin-outs, our startup companies are spin-outs, but 80% of our revenue is from the blast-outs. So that's just how it works. Okay, so now think about it, how you might approach these different pathways. And there are actually three general ways to do it through the, either as a founder or as an early employee. And one way to think about this is if you look at a startup on one scale is the product status, if it's just just a concept or actually proven, and then the team status, whether there's no one there or it's actually an emerging growth team. You might want to think about whether you want to get involved as a founder or as an early employee. And those are two different approaches. I'm just skimming over this now because we only have 20 minutes. Normally this is a 1-hour presentation. I'd go into detail about these two roles. But it is in the PowerPoint stack that's on the web. You can look at that. But the founder approach actually has two ways for you to approach this as a founder. One I call a co-founder. The other one is an Uber founder. The Uber founders are scientists and engineers that actually also want to do the business. So they take a lot of the business courses and a lot of these extracurricular events, and they become savvy in business. And so that they often they take a lead role in both the business side and the engineering or science side. Eventually, of course, they form a team. The other model is the co-founder model, where an engineer or scientist will quickly team up with like a business person that has relevant experience. And these approaches have pros and cons. I sometimes think the co-founder approach is better because you have more resources, but then sometimes there are interpersonal dynamics that you'd be surprised can really, because the startup is a lot of emotion and a lot of work, and these people don't get along, or if there's some tumultuous decisions to be made, that can be a tough thing to keep people together. So, and then when you're thinking about these roles and trying to leverage the UC Berkeley innovation ecosystem, it's very vast. Some people consider it a big black box. It's really hard to figure out what resources are there for you. So to help you with that, we just launched a beta version, working on this kind of a navigation system. It's a website that breaks all the resources, programs, and events into these 5 categories. This is a beta version, and that's all is now accessible through this link here. So if you go to the website, you can start to navigate some things there. And again, if you have questions, feel free to call me and follow up on how to deal with that. All right, so that's kind of the how to spin out a startup. Let me move into licensing. Let's see, I have about 10 minutes. So let me start by saying that UC Berkeley's objective in licensing is not just to make money. It's really to establish agreements and relationships that get the technology commercialized as fast and as broadly as possible for the benefit of the public, to support research and education on the campus, and to reward the engineers and scientists who created the technology. A lot of people think licensing is just a way to extract money, but actually, when it's done well, it's actually supposed to catalyze commercialization. Here's how that works. If you look about the risk to commercialize the technology and the potential return on investment, because a lot of research university technology is so early stage, the risks are often higher than the potential returns. However, if we can give a company, for example, an exclusive license on the technology so that they can increase their profit margins or their revenue, sometimes you can take a technology and get it over that decision point line where they can get investment capital to fund the technology. And that's an example of how a license catalyzes commercialization, not just transfers technology. So there's a lot of reasons why your startup might want to license intellectual property from a university. Here's kind of a continuum. For the best reason is what I just mentioned earlier, because you want to establish competitive barriers and improve your business model. But you'd be surprised, a lot of startups, universities, just want to license technology to impress their investors. It's like marketing for raising capital. And if they have licensed technology from like a UC Berkeley or an MIT or Stanford, then it's impressive. And so even if the patent rights aren't that great, it looks good, and so they'll go and license it. And then there are other reasons down here as well, for example, to cross-licensing and so forth. So in terms of licensing, even though it's one word, it's actually, there's a lot of types of agreements. I'll highlight those in a moment. There's a full license agreement, there's these option agreements, and these letter agreements. There's different terms for patents and copyrightable software, exclusive and non-exclusive, different fields of demarcation. So there's a lot of variables in here. And if you work with us and you want to talk to me, I can help you kind of parse the license. There's basically 3 parts to it: financial, legal, and operational terms. And everyone always asks me, what's the price? And one thing I want to point out that's not necessarily intuitive, the pricing on a license for patentable technology or copyrighted software is not based on how cool the research is. You can have some really cool research, it gets a lot of funding, and it gets a lot of press, but if it's technology that's going into a market with low gross margins or tough economics, that's how we price the license. We price it based on the business, not based on the on the research. And so a good example of that is, I mentioned earlier, maybe I didn't use that example, students came to me, they wanted to look for green technology. In this case, I introduced them to a professor that's creating biofuels out of algae, in which he's making isoprenes. And so that was very interesting research on, and I kind of tweaked the genome of the algae. And, but the fact of the matter is the product was going into fuels, which is a commodity. And commodities have very low gross margins. So that's how the license had very low royalty rates and things like that, because that's what's relevant, not just how much the technology was innovative. So when you think about licensing, you might want to think a bit on this continuum here. And in the context of a startup, it's all about risk management. And a lot of your startup, you think about it that way, managing risk, not taking risk, managing risk. And so the license, likewise, is a lot about risk management. So, for example, as your risks go down, your commitments to the university go up, and your payments go up. So, for example, let's just say that you're still evaluating the technology. So all you have to do is sign a simple confidentiality agreement with the university, and there's almost no commitment. If you're if you're getting a little bit more confident in the technology, you can do what we call a two-page IP rights letter agreement, and that's just requires a commercialization plan. Maybe you pay a little patent cost, and it's just kind of a baby step. The next step, if you're getting even more impressed with your technology, is to go to an IP rights option agreement. So that includes maybe some annual fees, some performance diligence terms, and these things. And finally, if you're really confident that you're going to be successful, at least you're going to be able to produce a product, you can jump to a license agreement. That includes these fees, royalties, and other stuff. And so your commitment is commensurate with your risk. And that's how we try to make the license work for a startup. And it also relates to the complexity of agreement, which brings in attorneys. If you're thinking about using an attorney to represent your startup with a university, if you're doing a simple two-page IP rights letter agreement, that can be just for a few 6 to 12 months. My advice is you don't even need attorneys, because there's not a lot of risk there. As you move up to scale and you want to do like a 30-page license agreement, then you maybe want to bring in a third-party attorneys to help represent you to make sure you're comfortable with the agreement. Okay, so that is a summary of ways to think about licensing. This now moves into patenting, and again, I want to leave that for my fellow speakers. So I just want to say a few things about disclosing inventions and copyrightable software. As part of your employment with a university, you're asked to disclose patentable inventions and copyrightable software. Often it's also part of a funding agreement with the university, whether it's for the federal government, the state government, or some corporation. But that's intellectual property rights from patenting and copyrightable software. You own your own know-how, and so you can use that in consulting and other agreements. And then the other thing to keep in mind here is when you're disclosing an invention to the university, that's not a patent. It's not even a patent filing yet. And that doesn't mean that you're saying the university owns it. You're just being upfront and transparent with the university so that we can work out who owns it and how we want to deal with it. And there are times when we think that maybe we're not going to do anything with it, so we'll give the co-inventors or co-authors the opportunity to take it on their own. And so again, the invention disclosure process is not like you're handing over something and you never have anything, any recourse. All right, and that's, so with just a few minutes left, that's a summary of thinking about startups, intellectual property licensing, and disclosing intellectual property. Any quick questions before we move to the next speaker? Oh, back here.
So, Mike, what's the typical process if one of us, a graduate or a postdoc, wants to license technology? Where does it start? Where does it end?
All right. Right. So the best way to answer that, the question was, if you really want to license a technology, where does it start? Where does it end? And again, think about, so you would engage our office, contact me or something, and we first ask you for a commercialization plan. This commercialization plan right here. And that would tell us kind of what your timeline is, what markets you're going after, and give us a sense of the economics of your business. And then we just work with you, decide where you want to be on this continuum. Do you want to start with a simple 2-page letter agreement? You want to start with a modern 10-page IP rights option agreement, or you want to go to a 30-page license agreement? And sometimes you take baby steps. Sometimes, for example, your investors might say, no, we want a license agreement. We want to know what the royalty rate, we want to know the business model. And we'll do the right thing with the startup. But that's so the first thing is, where are you on this continuum? And once we know where you are there, then we'll take you we'll discuss whether you want exclusive or non-exclusive, whether you want field of use, demarcations. And so that's where it gets more detailed. And again, this is one thing I like to emphasize. This is not an adversarial relationship between you and the university. We try to make this a win-win. In fact, we want you to be a success story that we can put up on our website. So you're going to have a lot of adversarial relations maybe with your partners or even sometimes with investors. You know, they have a different perspective on where they want to take the company. But with the university, especially if you're from the university, like a postdoc or an alumni, we really want to make this successful, and that's how we kind of figure out where we are in this continuum and drive the terms accordingly. Any other thoughts or questions? No? Okay, good. Let's move to the next speaker.
All right, let's thank Mike one more time. All right, so I forgot to mention we're doing a slightly different format today. We'll have 3 speakers at 20 minutes apiece compared to our normal 1 speaker for an hour. So please, let's try to hold the questions till the end so we can have an eventful panel discussion afterward. All right, so our next speaker is Carole Bellis. She is a partner at Kilpatrick Townsend's Mergers, Acquisitions, and Securities Group based in Silicon Valley. Her practice is focused on the representation of startup and rapid growth companies, many of them spin-offs of university-owned intellectual property. She has formed over 500 companies and regularly assists clients with matters relating to corporate governance, securities issues, mergers and acquisitions transactions, intellectual property protection, and licensing matters. She often serves as outside general counsel for her clients and regularly advises boards of directors and senior management on a broad spectrum of matters affecting small, growing companies. Her mergers and acquisitions experience includes domestic and cross-border transactions, stock and asset-based transactions, spin-offs, and going private transactions ranging in value from several million to several $billion. So please welcome Carole Bellis.
Hi, great to be here. I'm doing a lot of work lately with UC Berkeley companies, and we really feel like there's just so much great stuff going on here at Berkeley, and we're very happy to be working with you. In particular, I work with a lot of the QB3 startups, one right across the hall, Valitor. I don't know whether any of you guys work with Wes Jackson or know of him, but and that's also Kevin Healy and David Schaefer, who are here in this building. So anyway, we're really enjoying our work with UC Berkeley, and welcome the opportunity to talk with you tonight about it. Naresh mentioned that one of the things one of the first questions that comes up when you're forming a company is what kind of company do I form? So I wanted to go through a little of that with you. Let's just sort of start, but one of the first questions is, do I form an entity and when? I would suggest that you're not going to want to license the technology from the university in your own name. So one of the first things you're going to want to do, you want to have a company that's actually going to do that. Before you start going out and talking with people about what you're going to do, you want to have a confidentiality agreement in place. Well, I think it's a little awkward to have people sign a confidentiality agreement with you personally. So it's a lot better to have a company to do that. From liability issues, you don't personally want to be sued for infringement. Those are very big, expensive lawsuits, nothing you want to be involved in personally and put all of your assets at risk. So, those are all the reasons why you want to form that company very early on. And from my standpoint, if it goes nowhere, you basically, there are a lot of abandoned companies out there. It's not a big deal to drop it. So it's not a major decision. Oh my gosh, what do I do? Just go ahead, form that company. What do you form? Do you form an LLC? The biggest questions are, is it a corporation or an LLC? You'll find that, and then corporations are state law entities. So you choose a state that is the state in which you're going to incorporate. Options here, if you're here in California, would be generally California. Delaware is another big choice and generally the most popular choice for a number of reasons we'll get into. We all love California, but when you're forming a corporation, you may want to think about Delaware. In terms of types of entities that you can choose. The most common that you'll hear about are limited liability companies and corporations. There are several types of corporation now. A regular corporation basically is just called a C Corp. A S corporation is a small business corporation, and then a B corporation, which is a benefit corporation. It's a very, very new form of corporation, and it's not available in all states. So, going back to sole proprietor, the no setup required, and there's no corporate tax on sole proprietors, but for all the reasons we discussed, you don't really want to go there. Limited liability companies. If you go to an accountant and ask them what kind of company you should form, they're all going to tell you to form a limited liability company. If you go to a corporate lawyer in Silicon Valley and ask them what you should form, they'll tell you to form a Delaware corporation. So I think what I'll try to do is walk you through the reason for that. And it's not always the 100% certain answer, but I would tell you, in the most significant number of situations, you're going to be wanting to form a Delaware corporation. But limited liability companies are basically a company by contract. So you basically have a document called an operating agreement or a limited liability company agreement where all the people who are owners of the company have this contractual agreement of who gets what in various circumstances and what kinds of, who's going to manage it and all of those things. But it's all in a document. And that document, when you try to do a startup company and have multiple classes of stock and have an option pool to incentivize people to work with you and things like that, can get very cumbersome and very expensive. I've done limited liability companies that cost $250,000 to draft and require continuous update when you bring in rounds of financing. So, for the types of companies that you guys are interested in forming, it's not a great choice. You can avoid corporate tax, and you can pass through the income and just put it on your personal tax return, and that's all well and good. But the reason that the tax accountants will recommend this is because you can write off the losses. Technically, they say you can write off the losses, but to write off the losses, you have to have some income as well to write off the losses against. And most of these startups are not going to have any income, and most startup entrepreneurs do not have a whole lot of income from which to write off these losses. And frankly, it doesn't make much sense to go through that whole rigmarole. When, in fact, what you guys want to do is be in a position to bring in outside investment. You're generally going to finance this company with outside investment, and that's going to come in the form of, equity investments, issuing preferred stock, and with, you can't do that in a limited liability company. It's not to say, there are some ways you can do these things, but by and large, the investment community wants to invest in a corporation, and they want to invest in a Delaware corporation. So, corporations, some of the benefits. Very, very easy to set up. Every law firm in Silicon Valley can set up a corporation in Delaware for you in about an hour. It's just not a hard thing to do. We all have the paperwork. My firm, we have a set of about 20 documents that we'll prepare in a formation. We'll issue all the stock to the founders. We're going to give you forms of consulting agreement and advisor agreements and employment agreements and NDAs and all of these things. We'll put all of that in place for you. I have an automation system. I spend about an hour talking through what are the decisions you're going to make. But when I enter in some basic information, I can generate those forms and everything for you in about a minute. So it's really, sort of there's some decisions you need to make that go into that, but really the actual formation, this is not a big deal. It can be done quickly. S corporations, an S corporation election it's basically a tax election. It allows you to actually get taxed as though you're a limited liability company. In some instances, people want to do that. It's probably a better option than a limited liability company. In some reason, it's cheaper to form and do it. But at the end of the day, you can only issue one kind of stock. You can't bring in preferred stock, which your investors want, all of those things. S corporation, not really a great idea. The newer form, this B corporation, is something that might be pretty popular. You know, it's actually still pretty new at this point, but it's a corporation in which you basically, in your initial formation documents, you specify a purpose. So you might have some really good humanitarian type purpose for this company, and where usually in the law, the obligations of your board of directors is to maximize shareholder value, basically make this company as valuable as possible, and that's the only thing they can look at in making company decisions is this, you know, the way to maximize the value of this company. But this public benefit company, basically by having this stated purpose, it allows you to also consider that you know, potentially altruistic goal that the company has in making corporate decisions. But it's a very new type of corporation. We're beginning to start a few of them, but you know, anything that's new, there's just a big unknown in terms of how regulators would look at these, what problems might exist. So for those of you who just want to you know, go with the flow, get out there, give the investors what they're looking for, you know, the answer is really just the Delaware corporation. So I think you know, Delaware, why do we do these in Delaware? Delaware has just really invited companies for years to form there, so they have this vast number of corporations who have formed their entities there. Because of that, there's a lot of lawsuits that have gone through the courts. People really kind of know where they're going to come out on these kinds of decisions. They've been very favorable to stockholders as well as to corporate executives. People, you know, investors feel safe when it's a Delaware corporation that these decisions will come down in ways that they're comfortable with. So for that reason, you know, investors like it. I can form a company in Delaware. We can file that certificate and have documentation back within an hour from Delaware. We all love California, but you know, some of these it can take months. Generally, we can get it back in weeks, but you know, you can talk months. I mean, just to get the paperwork back, it's, you know, there are variations, and that's why another reason why Delaware is you know, basically the hands-on favorite. So here, I'm going to just take you through some of the initial, you know, basically the questionnaire we go through. I thought it might be helpful. Here are some of the decisions. I mean, one of the big things to form a company, we've got to have a name. So that's sort of a big gating item. You know, so some of the things you want to check is you can go onto the Delaware website and run the name you want through there and see if that name is actually available. You might want to do some sort of a trademark search. You definitely, before you file, you want to get your domain locked in, because if the name of your company happens to be available, by the time it gets filed in Delaware and you go back on to GoDaddy, it will be gone, Daddy. So get that done first. Generally, I mean, changing a company name happens all the time. Sometimes VCs want to have something a lot more sexy than what you might have chosen. For whatever reason, you decide to make changes. It's not that hard. It's just that, you know, to the extent that you've developed any name recognition in communities, obviously you lose that. So, but you know, I wouldn't stress too much of it if you haven't, you know, if it's holding up you getting incorporated. Just, you know, XYZ Corporation. Just get it done. Directors and officers. For those of you who are, you know, UC faculty, you have policy considerations here. You can generally be directors of a company, but you cannot serve as officers, and so you'll need to find somebody else to take your officer roles. The typical officer roles that we appoint are the CEO, treasurer, and secretary. Delaware is also a very nice state in that we don't necessarily have to appoint all those. We can get away with just a secretary. I am actually the only officer for a number of the companies that we work with, while they're basically faculty members who are the directors, and I serve as secretary at some point when they're many of these companies are just being formed because we want to apply for an SBIR grant, and we have to have a company, and we have to be able to open a bank account and those sorts of things. So sometimes it's okay to just have the corporate secretary. But you can be all three of those if it's a sole founder and you don't have a policy that prevents you from taking an officer role. You can wear all of those hats. That's okay too. With respect to the board, wanted you to, you should think about, there's a difference between the board of directors and an advisory board. You don't want to just add a bunch of people to your board of directors. The board of directors is the body that hires the CEO, hires and fires the CEO, and that really makes the big decisions for the corporation. If you're the biggest stockholder of the corporation, you probably want to be, you maybe want to be the only director of your company, and you don't go around and find a bunch of other people and make them directors, because they could ultimately, they could potentially fire you. So let's not do that. What you may want, though, is to have an advisory board. It's very common for people, if there's somebody that you're asking for advice and you're calling them on a regular basis and asking for their help, ask them to be an advisor for your company. It's a standard form of agreement that we give our startup companies. You basically offer them a few thousand shares in your company for whatever. It's generally a small stake, but it makes them feel good answering your phone call. They get a little stock, and they'll say, you basically want them to say good things about you, take your phone calls for up to an hour to a month, and help you make connections, and so so that's the role of an advisor, and we give you those forms of agreements. That's a good thing to do. And I forgot to look at my time when I came up, so I hope I'm not going too over. But I know time. I think I'm probably about halfway through. Okay. Next thing is how there one or more founders. How do we break up the stock? How does the stock get broken up in the company? So here is sort of a common breakdown. First of all, the founder's stock. So the people who are forming the company, how much do they get? Generally, 80 to 90% of the stock would end up with the founders, depending on these other elements. An option plan, an option plan is basically a tool for you to be granting people equity and letting people work for you and do things for you for earn that with stock, and so that especially when you don't have cash compensation to pay people, it's a very important tool to have, and that's generally 5 to 15%. There's been a trend toward lower option pools lately, but I generally don't recommend going over 15%. Basically, under the securities laws, you're only allowed to grant 15% per year. So if you only have 15% of your plan, you can't violate it. It's a safety device. The university, I think 3 to 5% is a good range. Yes. Okay. Great. Yep. And then lawyers. Sometimes lawyers ask for a percentage of the equity. Basically, I'll tell you a little bit more about some of the plans they have later on, but sometimes lawyers end up with a percent or two, or a little bit. Some of the equity considerations. So founder shares. It's amazing when you have two founders. They want to go 50-50. You have three founders. They say a third, a third, a third. I think a lot of that, it's an uncomfortable conversation to have. There are three of you. Who should get more? What should the right allocations be? And so more often than not, that seems to be the choice. It's not necessarily right, but one of the things we recommend, and I'll go into a little bit more detail, are having vesting attached to the shares, and that's a protective tool for the founders that will help you really try to make some adjustments later if you need to about what people get. You will want to make an 83B election if you have vesting, and your law firms can help you do that. It's just basically saying, go ahead and tax me now on these shares, and the reason you want to do that is because the tax now is 0. Let's see, so vesting of founder shares. So we'll often, a common vesting plan would be that, we're all going to start, we're forming the company this day, and we're going to vest over 4 years on a monthly basis. And so every month that we're working, we're going to vest in 1/48 of the shares. And what that means, it works like reverse vesting, basically, is that if I, let's say I'm 1 year into it, I got 1 million shares. We're 1 year into it, I have 250,000 shares vested and 750,000 shares that are not vested. If I decide to take a job on the East Coast and leave the company, I can walk away with 250,000 shares, but the company has the right to buy back the remainder at a at the price paid, which is generally a fraction of a penny. And so the company generally will buy, $30, buy back the shares of that departing founder. It also enables you, if somebody's, the original feeling when you granted this 1 million shares that this person was going to be devoting full time to the business, and it turns out that they're not spending full time, then you just, you can basically say, look, you should only be vesting 50% of what, of what we had planned, and let's slow that down. And if you can later, get back up to full time with the company, then we can make that adjustment. So these are some of the protective devices that you can have. Sometimes, especially a new team coming together that hasn't worked before, it's nice to have a cliff, which is some sort of period before the first vesting event. It's very common for employees to have to wait a year before they have any vesting. With people who are working for no pay, it's a little harder sell to say you don't vest for a year. I'm going to devote a year of my life to this and have potentially walk away with nothing. So that's a little harder. But you might say going to go 3 months, or you make a deal. How long is it going to be before you have your first vesting event? Sometimes you want to have acceleration. I mean, what if I bring in, a venture capital investor and they fire me? I should get my shares. And so there are certain triggers, change of control, things like that. When if you have unvested shares, you might want some acceleration, and we can talk you through those sorts of things. So, I call this, the document we use to put all this in place is called a restricted stock purchase agreement. I call it the founder's prenup. It's very similar to that in many ways. You're getting into this. I mean, the people who should really, get the money at the end of the day are the people who stick with it and go the distance. And so, you want to make sure that you get this document in place. It also has various, repurchase terms. If you can't just sell your shares to, some other party and without first letting the company have the opportunity to buy it. So if somebody's willing to pay $10 a share, you would tell the company, I've got a buyer for $10 a share, and the company has the choice of saying, well, you know what, we'd rather not have this person own the shares, we'll buy them. And maybe they're okay with it. Maybe they say, fine, go ahead. But those sorts of things are in the restricted stock purchase agreement. I think that, that's basically the general part of it. We can talk more about this over the question period. You want to go to the next?
Questions during the...
Yeah.
During the session. Right. Our third and final speaker is Dr. Joe Howe. He's a partner in Kilpatrick Townsend's Health and Life Sciences term. Dr. Howe focuses his practice on preparing and prosecuting patent applications and assisting clients with formulating international patent filing and prosecution strategies, freedom to operate analyses, due diligence reviews, and validity non-infringement options, and patent portfolio management. Dr. Howe's experience spans numerous disciplines and industries, including diagnostics, biologics, nucleic acid therapies, protein engineering, immunotherapy, molecular and cellular biology, genetics, neuroscience, stem cells, drug formulations, drug delivery, pharmaceuticals, and medical devices. Dr. Howe represents universities as well as a variety of startup and publicly traded companies in the biotechnology industry located in the U.S., Canada, and Europe. Dr. Howe also facilitates the development of relationships with existing and new clients located across Asia. So please welcome Dr. Howe.
Hi, everyone. First and foremost, I want to thank Lance and Naresh for inviting me to speak at your event. And I just want to first mention that I do represent numerous startups through the QB3 Startup in a Box program. And representing startups can be a challenge, but it's also, some of the most rewarding and interesting, discussions and conversations I've had with, with the founders of these various startups that I represent. And I'm sorry to say that, unlike Carole, I cannot draft a patent application in just a minute. It often takes a lot longer than that. So I'm just going to give you a very general overview. A lot of the stuff you may already know, and I apologize in advance for that, but hopefully, you'll take something away from this, and we can always discuss in greater detail during the Q&A portion. So just an overview of my short talk today. I'll give you a very quick introduction to IP, the various types of IP, why patent your invention in the first place, what are the benefits, advantages of doing so, some patent basics, and just a quick slide on patent strategies for startups. So why IP? IP allows you to, leverage your intangibles, that being your invention, your technology, things that you come up with, right? Things that you conceive, your inventions. And so IP is basically this intangible asset that you have that, we feel very strongly, should be protected like any other valuable company asset. Think of it as property, so to speak, and, hence intellectual property. And as we move away from the industrial age and into the information age, leveraging IP is paramount to any company and startups in particular. The different types of IP, patents, trademarks, copyrights, and trade secrets are the legal tools that protect these intangible assets. And the use of these tools can prevent the further loss of value and convert your ideas into this tangible, into a more tangible form. And so we believe that having a custom IP strategy, and especially for startups, should be developed to suit these various factors. The first being the type of business you have. The second being the products that you intend to develop and hopefully commercialize in the future. Also, what are the actions out there by your competitors? Are your competitors active in protecting their own IP, or is it generally free, free game for basically any company that gets out there in that space? The litigiousness of the industry, having patent protection basically gives you the right to sue, and it can also prevent others potentially from suing you in return. And so, are you in an industry that, where companies like to sue each other, or, is there more perhaps respect for each other, in that particular company, more cross-licensing deals that go on in that particular industry. Also the funding cycles, how do your potential investors, VCs, how do they feel about IP in your particular sector, in your industry? How do they value IP? And also, the size of your company, the growth strategy that you have in mind for your company. And, finally, something to think about, is exit strategy. I know that may be, far in the future, but, do you intend to go IPO? Do you intend to be acquired? Do you want to out-license your technology? These are all considerations that are kind of built in and go into, developing a comprehensive IP strategy for a startup company. And then, also important is, to be able to balance costs of protecting your IP, versus the IP protection itself for your startup. And, we can create customized solutions, within a reasonable budget, because I'm sure most of you are aware, filing patent applications and prosecuting them before the various patent offices, can be quite expensive. And when you add on, international patent protection and prosecution there, across the world, that basically drives the cost up, almost exponentially sometimes, depending on how many countries you want international rights in. Oops. It's not going to the next. I think I pressed the wrong one. There we go. Oh, thank you. So just a very brief overview with respect to the types of IP. I'm going to be focusing on patents for the most part. That's my area of expertise. And as I'm sure many of you are aware, patents are considered a negative right. They confer the inventor the right to exclude others from making, using, or selling the invention. In other words, they don't give you the right to actually practice the invention. They give you the right to exclude others from doing so. And so, very similar to patents, and in my next slide, I'll go over kind of the differences between patents and trade secrets and the advantages and disadvantages of each. But trade secrets are defined as any secret formula, pattern, device, or compilation of information used by the company that gives it an economic advantage over competitors. And as you're probably aware, one of the most famous trade secrets is the formula for Coca-Cola, and another one is probably the secret blend of herbs and spices for KFC chicken. And so those are all considered trade secrets. And then there are copyrights which protect the work of original artistic expression in tangible form, and trademarks. And as far as copyrights and trademarks are concerned, I'm sure you guys are pretty familiar with those. You see those on a day-to-day basis, and so I'm not really going to go into much detail about those. All right, so patents versus trade secrets. So some of the advantages of keeping your technology or invention as a trade secret and not disclosing it to others or to the patent office is that patents, like I said, require public disclosure. Trade secrets do not. It's kept a secret by definition. Patents are limited in duration, typically 20 years from filing the patent application. Trade secrets are not. They can last forever as long as you keep it a secret. Patents are costly to obtain and maintain, whereas trade secrets are not. Patents do not provide immediate protection. You have to wait. You can put patent pending on your products, but you typically have to wait for the patent to issue before rights, attach to the issued patent. Trade secrets do provide that, immediate protection that you don't get from patents. Patents require compliance with formalities. You need to basically, have certain requirements that you need to meet with various patent offices before they'll examine your application, before they'll issue claims. And so, there are all these kind of steps you need to go through to basically get a patent application to issue, whereas trade secrets don't have such formalities. But I believe, personally that, there are, these three disadvantages and potentially many others that, to me outweigh the advantages of trade secrets. One of the disadvantages of trade secrets is that others may be able to discover the secret through legal means, such as reverse engineering, and thereafter they're entitled to use whatever you've kept a secret. And I think even worse is that if they do obtain it by legal means and it hasn't been patented, of course it hasn't because it's been kept a secret all along, they can actually go ahead and try to patent whatever secret they've reverse engineered. And so, there's a lot of risk, I think, that a company, in general, and startups in particular, have to consider, when they are making that decision of should I keep, my technology, my know-how, my inventions a secret, or should I, try to obtain patent rights and disclose it to the public. And one last point is that trade secrets are generally more difficult to enforce than patents. Trade secrets are typically governed under state law, and patents are under federal law, and so, and I think there's just been, just much more, just much more out there in terms of, litigating patents versus trade secrets, and so, I think there's much more certainty with what's going to happen, if you do obtain a patent and, assert that patent against a third party. Okay, so I'm just going to spend a few slides on, why even patent in the first place? I think one reason is the fact that we live in an idea-based economy and that innovations drive the growth even more than new capital investments these days. And keep in mind that since the time of the constitutions, we have always embraced innovation. And so for more than 200 years, the world's most market-based economy, the US, has granted temporary monopoly rights to anyone who comes up with a new invention. And I'm not sure if you're aware, but in the Constitution itself, the Founding Fathers basically gave Congress the right to promote the arts and the sciences by providing inventors exclusive rights to their discoveries. So basically, the patent right was built into the Constitution because the Founding Fathers, just knew how important and valuable that would be, to the country. And I think, another reason to patent your technology is that investors clearly believe in the value of patents. I found this 2013 study by Cohen et al. That covered more than 8 decades of patents from 1926 to 2010, and they found that when a company receives a new patent, its stock market value increases on average by $19.2 million in 2013 dollars. Of course, that's an average of all the companies, right? So it's not one particular company whose stock market value increases by that much. But even setting aside such blockbuster patents as the core inventions from Apple or Google, the study found that the median jump or bump in a company's stock market valuation after receiving a patent was still 5.9 million. So it's still a substantial amount. Upon obtaining a patent for the company. And I thought another interesting fact was that U.S. companies and individuals hold about 25% of the world's patents, but we account for roughly half of all worldwide VC investment. And I think this shows the willingness of U.S. investors to fund the young enterprises that often develop the new patentable advances, inventions, technologies.
So Joe, what is the value of this patent for a startup company? Does it go by $6 million or $8 million?
What is the value of a patent for a startup company?
Yeah.
Well,
There's a valuation of the company.
well, I think it's for all these reasons. I think we've talked about, for investors is a big one for most startups. And I think for all these reasons I'm going to go through in the next couple of slides as well, which hold true for startups as well as for other companies. But yeah, so again, why patent? Patent, like I said before, gives you exclusive rights to prevent or stop others from commercially exploiting an invention for 20 years from the filing date of your patent application. Patents can also reduce competition. You may be able to do that and provide a competitive advantage for your company by discouraging others from copying your patented features and entering the market, and that can, in effect, protect your market share. Patents also give you a return on your investments. As you move forward and form and develop your company, you'll have invested a considerable amount of time and money in developing your technology, and through exclusive patent rights, you may be able to establish your company in the market as a preeminent player and obtain higher returns on investments. And of course, there's also an opportunity to license or sell the invention if you're not going to develop and commercialize it yourself. And you can use that as another source of revenue for your startup. A couple other reasons why we think patenting your invention is important is it can be used to increase your negotiation powers. If your company is in the process of acquiring the rights to use the patents of another company through a license agreement, your patent portfolio, will likely enhance your bargaining power and give you that leverage in your discussions with that other company. In other words, your patents may prove to be of considerable interest to the other company, and you could enter into a cross-licensing agreement where you and the other company agree to license each other's respective patents. And I think that also the existence of your patents may provide a disincentive for competitors to assert their own patents against you, and instead open up cross-licensing opportunities. And finally, like I said before, obtaining patents, applying for patents just provides a positive image for your company. Business partners, investors, in particular shareholders alike, may perceive your patent portfolio as a demonstration of the high level of expertise, specialization, and technological capacity within your company. And this may prove useful for raising funds, for finding business partners, and for raising your company's market value. So I think for all those reasons, and probably many more, you know, of course I'm very pro-patent, but I think, you know, those are some very compelling reasons as to why companies and startups in particular should seriously think about patenting their technologies and their inventions. Just quickly, some patent basics. There are 3 types of patent applications in the US. There's the utility patent application, which covers any useful, novel, and non-obvious machine, process, article of manufacture, or composition of matter. And the utility patent application is what I'm sure most of you guys are most familiar with. Those are the most common. There are currently over 9 million issued utility patents in the US. A second type of US patent application is known as the design patent application, and those are filed to cover a new, original, ornamental, and non-obvious design for an article of manufacture. Although design patents are kind of, you know, less popular and, you know, most companies don't file design patents. I mean, they're certainly not out of the news. You know, as you're probably aware, you know, Apple asserted, I believe, 4 of their design patents against Samsung, and was, you know, generally successful in those particular assertions. And a third type of U.S. patent application is the plant application, and that type of application is used to protect any new and distinct variety of asexually reproducing plant. I've never filed a plant application myself, but we do have a few plant PhD biologists in our team, and I believe that they are well experienced with that. So I'm just going to focus on the next few slides and just talk about the various types of utility patent applications. There are 2. The first one is a non-provisional application, and that application is basically the application that you're probably most familiar with. It's the one that is examined by the patent office. It's the one that matures into an actual patent. Non-provisional applications typically publish 18 months after their earliest priority date. And after that, you know, they're available by searching on the USPTO, United States Patent and Trademark Office website. You can search for published patent applications. They publish I believe they publish every Tuesday, and patents also issue every Tuesday. And so the other type of utility patent application is called a provisional application. These are much more popular in the biotechnology, chemistry, life science areas than they are in the high-tech sector, where inventions just are, you know, much more, they move at a much faster pace. And so with respect to provisionals, a lot of people like to think of them as a placeholder, and they basically are filed in the patent office, and you don't need to file them with any claims. They're neither published nor examined. Filing a provisional application does not affect your ultimate patent term. It's only when you file the non-provisional that you have 20 years for filing a non-provisional before your patent expires. And provisional applications expire 1 year after they're filed. At that time, you must decide whether you want to convert the provisional to a non-provisional application. And I think the most important uses of a provisional are the fact that, 1, it establishes a filing date to secure any U.S. and foreign rights right before you make a public disclosure. If you have an abstract or a manuscript or an SBIR grant that you're about to, you know, submit, or that's under the review process, and there's any potential chance that it could be published online, or the abstract could be published online, or there's just some imminent public disclosure that you might be anxious about, you know, the best strategy is to file a provisional application just to put your stake in the ground and to protect yourself that way so that you don't lose any U.S. and foreign rights, mostly foreign rights. A provisional application also provides you with 1 year to evaluate the marketability of your invention, and as I found in the biotech sector, it provides the inventors 1 year to generate the data to support basically the scope of the provisionals. You know, I often try to put claims in the provisional, and so generally the claims, when the provisional is filed, could be quite broad, and the inventors are given a year to basically, you know, try to support the scope of those claims with some experimental data. And by filing provisional, you can label your product as patent pending. And so this is just a quick timeline of what that would look like. So, so you have a provisional filing date, and then 1 year later, that's when you convert the provisional to a non-provisional. And then at some point in time, typically it takes about 3 to 5 years. Although, as Naresh will tell you, we filed a fast-track application for his company, Nausicom, and we just received a notice of allowance, I believe, maybe like 8 months after filing the application. So, you know, there are ways to fast-track your application, especially for a startup, if you want to get that patent issued and, you know, present it to investors. So after your patent issues, and then, you know, 20 years from filing the non-provisional, that's your typical patent term. And so just quickly about foreign patent applications. As you may know, a patent is only enforceable in the country where it's issued. And the right to apply for foreign patents may be lost immediately upon public disclosure, like I mentioned. But the rules vary by country. In the US, inventors are given a 1 year grace period, where if you publicly disclose something, you have a year to file a patent application. But in Europe, where it's called an absolute novelty jurisdiction, if you don't file your application before you disclose it to the public, then you've basically lost most of your rights. I mean, you know, for the most part, you probably lost most of your rights. I believe Canada gives you a 6-month grace period. But most countries in the world, and Europe being the most, I think, important example, if you don't file a patent application before you publicly disclose your technology, you're basically, you know, you're screwed, for lack of a better word. And you know, as you can appreciate, each country will require its own filing fee and translation costs, you know, if those are applicable. And finally, I just want to mention there's this one type of patent application called the PCT application. It stands for Patent Cooperation Treaty, and it's essentially an international application that you can file. Instead of filing a U.S. non-provisional application, you can convert your provisional to a PCT application, which is an international application that delays entry into member states until 30 months from the earliest priority date. So that gives you a way to basically extend the decision of whether you want to file in the U.S. as well as other foreign jurisdictions like Europe, China, Japan, Australia, Canada, until 30 months from the earliest priority date. PCT applications publish 18 months after the earliest priority date, and like I said, it enables foreign filing decisions to be made at a later time after small companies are able to obtain funding. But there are a couple of notable non-PCT member states, Taiwan and Argentina. You know, most high-tech companies like to file in Taiwan, and the only way to do that is to file directly in Taiwan at the same time you file your PCT. You can't file in Taiwan off of the PCT application, so you can't delay that decision. Okay, so just one final slide, just some thoughts on patent strategies for small companies and startups. You know, we appreciate that funding is usually tight, so we believe that the patent strategy must be focused, but we don't think that it should be ignored. You can also in-license technology, you know, for example, university-owned technology to get a competitive advantage in your industry. Small companies are typically under the radar of larger companies for some time period, so, you know, definitely take advantage of that time period. And a patent portfolio should be developed before a small company gets a large company's attention. You know, think of, you know, success of your company, you know, being equal to, you know, being on the radar of a large company. And, you know, we believe that the quality of the patents is more important than the quantity. You know, having one complete, strong patent application that covers your platform technology, for example, we believe is a much more worthwhile investment for you than having just a bunch of, you know, provisionals that, you know, protect one aspect here and there, but could be easily kind of combined into one filing. And so, you know, those are certainly strategies that we can work on with you in terms of how to structure your patent strategy and how to develop your patent portfolio going forward. And again, like I said, foreign filing decisions may be started in the hope that funding will be obtained to pay for the large expenses that soon follow when you start to enter these individual countries 30 months after the earliest filing date. And then, we believe that due diligence should be performed to assess the patent landscape and identify any patentability and freedom to operate issues. And, as you'll see when you talk to investors, that's one thing that is important to them, is whether due diligence has been done, on behalf of the company, whether the company's inventions are patentable and whether the company has freedom to operate in that space. And so I think with that, I'm done.